Hello, I'm Alastair Hudson, and this is an introduction to international and comparative trusts law. Now, just to explain, it's actually my colleague and co-author and friend, Professor Geraint Thomas, who leads this particular course. But I'm the author of some of the materials that appear on the course, and I'm just going to give you an introduction and overview to how the course works. So, international and comparative trusts law, what's all that about? This is a very, very practical course, and it deals with a lot of issues that are significant to trust law practitioners in the world. The trust in practice is used for four things, I think, more than anything else. Firstly, it's used for asset management, the way in which you might try and organise how your property, whether that's your home, a second home, shares, other kind of property, money, is going to be held during your lifetime or after your death for other relatives and so on and so forth. It's less and less common for people who are well advised by lawyers and accountants to leave wills. It's more common nowadays in the UK and in the USA for people to create trusts during their lifetime, which organise what entitlements they have to their property during their life and how it will be organised beneficially for their relatives after their death. So clearly trusts are just a very benign, ordinary way of organising our affairs. And the great thing about the trust, as you may know about trusts, is that they're created classically by somebody known as a settlor. That's the outright owner of the property to start with. And they appoint a person or people to act as trustees. And those people don't become the owners in any beneficial sense of that property. Instead, they're more like stewards, more like functionaries. They'll often be paid professional advisors doing that work. Not always, but usually. There'll usually be some paid professional advisors in there somewhere, if it's a wealthy individual who's creating this trust. And then there is a person or people who are identified as the beneficiaries. And they're the ones that have the real beneficial ownership of that property. Now, the beauty of a trust is that it's endlessly flexible. You can create large numbers of trustees, you can have almost infinite numbers of beneficiaries, and you can, importantly, have beneficiaries with different types of right. The most obvious in English trust law history is that you would have someone who is known as the life tenant, who would have rights during their life, and then other people that would have rights after that life tenant died. So there's an obvious example of how you can have different types of beneficiaries. But it can be much more complex than that. Investment structures like unit trusts, for example, will have very large numbers of beneficiaries who all have small rights compared to the size of the total fund, dependent on how much they have invested in that fund. So there's another way in which we can organise the trust. But the important side of the trust, typically in practice then, is who are those trustees and what powers and what obligations do we give them. So that's the first kind of basic asset management approach to a trust. That trust can then also be used for a second purpose, which is tax avoidance. So if you're clever and you structure your trust properly, you can minimise the exposure of those various beneficiaries or the settlor to tax. So that, for many people, is beneficial. And that's where the international element starts to come in. Because there are some jurisdictions in which trusts will be taxed differently from others. There are some jurisdictions which allow trusts to be organised in different ways from other jurisdictions. And so within all of that, there's something which is known as jurisdiction arbitrage. If you organise your trust in a particular way, if you organise it in one jurisdiction rather than another, it can have a different tax treatment. The third possible use of a trust in general terms then would be regulatory avoidance. It might be that you're trying to avoid oversight by a particular regulator. Now this can be a benign or this can be a ethically questionable activity, but you might be trying to put assets in a jurisdiction so they're not overseen by a particular financial regulator in one jurisdiction rather than another. It might also be a tax authority that you're trying to put your assets beyond. So trusts can be used as vehicles for that. And it's trusts in jurisdictions outside the UK and outside the USA, the so-called offshore jurisdictions, which are often used for that kind of purpose. So we're thinking of jurisdictions like the Cayman Islands, the British Virgin Islands, and so on and so forth. And then the fourth typical use of a trust is to protect the settlor or other people against insolvency. So if I'm concerned I might go into insolvency in the future, one thing I might do is to put all my property into a trust and structure the trust so that I'm one of the beneficiaries, but so that my beneficial rights are extinguished in the event that I go into insolvency, so the property passes to other people. Now, Many jurisdictions have legislation to outlaw that kind of activity, because otherwise, clearly, it'd be far too easy for me to declare a trust on a Monday before I know I'm going to go insolvent on a Tuesday, and so try and get the property beyond my creditors in that way. But how we can structure those things in advance, far in advance of an insolvency, just in a prudent way from the beginning of a business perhaps, and maybe the insolvency happens 10 years later. There are lots of ways in which you might try and manage assets to avoid insolvency in that sort of way. So what we can see is that trusts law has all of those sorts of objectives and many others. It's an endlessly flexible idea, the trust. But different jurisdictions around the world have different trust laws, and many of those jurisdictions have created their trust laws precisely to attract investors to those jurisdictions, because their trust law offers more propitious ways of avoiding tax, or of avoiding regulatory problems, or of managing your assets more effectively. So this course considers a large number of different jurisdictions. As I said, it's endlessly practical in that sense. And among the jurisdictions it covers, there's quite a list. There is the Isle of Man, there's Bermuda, there's the Cayman Islands, there's the Cook Islands, there's the British Virgin Islands, Belize, the Bahamas, Cyprus, Jersey, Labuan, and so on and so on. The list goes on. The course takes you through the trust laws of those various jurisdictions and what their benefits, advantages and disadvantages are in terms of operating trusts. Immensely practical and fascinating course. You also look at a very large amount of commentary between commentators from different jurisdictions as to the benefits and the disadvantages of these various models of trust. So it really takes any study of trust law you might have done far beyond what you would have done as an undergraduate student. It's also incredibly useful for those people in international trust law practice to see how the laws of different jurisdictions operate, and I think you'll find it incredibly practical and useful in that way. So what this course will look at is a number of legislative carve-outs, particular jurisdictions with particular statutes to allow their trusts to operate in different ways from traditional English trusts, and that's absolutely key to how this functions. That also shines a light on the same kind of avoidance of US tax, for example, where trusts are also used in the USA, but lots of people deal in offshore jurisdictions who are ultimately American investors. And it also allows us to get into the fascinating current debates about tax avoidance, generally regulatory avoidance generally, and the number of international initiatives, for example, by the OECD, to try and clamp down on this sort of activity. So this really is a constantly changing world that we're looking at, and a fascinating area of study.